Yeah. So good morning, everyone. I am happy to welcome you today to this new session of Mobile Heights Speaker Series. Through this series of webinars, we aim to share knowledge on intellectual property, and we do this in collaboration with our members, Potter Clarkson, Brann, and Sacco. My name is Carolina Garces. I am a project manager at Mobile Heights, and today I will be guiding you through this interesting webinar. Before we start, I would like to present our house rules. Important for you to know that this webinar is being recorded. So we encourage you to have your camera on, but in case you don't want to be featured, please turn off your camera. We highly recommend you to add your name and company's name as well in your Zoom alias. And you can do this, you can find this information how to do it in our chat. Today we will have an interactive session, so please feel free to use the chat to present your questions. And finally, it's good for you to know that you will find this webinar in our Mobile Heights webpage and YouTube. You can find also the presentation. With that said, I am glad to introduce you all to Casper Over. He is an office manager of the Malmo office at BRANN. BRANN is a full-service intellectual property law firm and works within the different fields of technology, offering services such as patent, trademarks, design, copyright, among others. Casper is a European patent attorney at BRANN, and he holds a PhD in physics from Lund University. He works with patent applications and litigations, and his focus areas are IT, mechanics, and physics. Today, Casper will explain us how patent activities support the overall business strategy and goals of innovative companies. Welcome, Casper. The floor is yours.
Thank you, Carolina. Thank you very much. I would like to add to the presentation that I love what I do, patents and IP, so that is clearly communicated. And today I'm operated at reduced capacity due to a virus, but I think that the impact on the presentation will not be that great. Let me see. Let me see. Please, Carolina, can you confirm that you can see the presentation?
We can see the presentation.
Okay, thank you. The topic today is patent strategy. Patent strategy is a very broad concept, and I will try to give you a structure when it comes to patent strategy. I will present a toolbox of different actions that you can take when it comes to patents in particular, and whom at your company that should use and operate this tool. So as a first step, we of course need to identify who can operate and should perhaps operate the different strategy tools. What I show here is a very basic model of a company, let's say. And I've divided it into 4 groups. We have management. And from now on, I use these letters to indicate as indications further in the presentation. So we have the management or management team, CEO, for example. And then there is a legal department or legal person, and there is a sales department, and there is a research and development department, and of course there is many times also production, but we will not discuss them today. So this is a innovation. This is a typical company structure, and many times when it comes to smaller companies, startups and so on, the same person may have several of these responsibilities. For example, the CEO can also be the legal responsible at the company or sales responsible. So it depends on the company, but I believe that you can identify the groups and the structures within the company that you are in. And more to understand the role when it comes to patents and innovation within the companies. These are two scenarios. These are typical scenarios. These are not typical scenarios. These are basic models. In real life, most likely there's a mix between these two that I show you. And to the left, we have the scenario where innovation and development is internally driven, while to the right we have the model where it's externally driven. And if we look at the left model, the internal model, innovation originates at the research and development department. And this can be through research or standardization efforts or ideas. And this is typically the case for startups, I would say. So a technical concept is identified by the research group. This is presented to the sales department. The sales department determines is this viable or not on the market? Is it possible to have a success on the product market? And perhaps also make the assessment, is this a disruptive or incremental innovation? Or will it be a disruptive on the market? And then the sales communicates with the legal department, and typically it results in a patent, freedom to operate analysis, or a novelty search, and so on. And then management makes a decision: should it be patented? How should we pursue this innovation? And one important thing here is that the research department knows the technology market. It is, and when I mean the technology market, we use this term for describing, let's say, patents, standards, licenses, the research activity of competitors. I mean, you should not, of course, develop something that is already known and protected by a competitor. So in this first model, internally driven, it is important that you have knowledge of what competitors do. And in the right model, the externally driven, it is the sales department that knows the product market. The product market is what is actually offered on the market. Services and products. So they should have good knowledge of the demands, the problems that are present. For example, customers communicating problems with the product or needs to better solve an existing problem. So the sales department collects information of what is needed to be solved, and then communicates this to the research department. And the research department comes up with a technical concept, which is hopefully a solution to the problem or a specific demand. And it takes it then to the legal department, who makes an assessment. Should it be patented, freedom to operate, novelty analysis, perhaps also mapping of if there is corresponding protection, to determine if the competitors or the markets are covered by patents preventing introduction to the market. And the monitoring of competitors is also important in this model. And then management makes a decision on the matter. And sometimes in both of these cases, you could make you could skip the communication between perhaps if we look to the leftmost, research can communicate directly with legal department so that they do not develop something that is already protected, should they not know the technology market themselves. And the same goes for sales department in the right model. If they know, if they communicate directly with legal department, they perhaps do not ask the research and development to develop something that is already protected by a competitor. So there are ways that you could improve this. But this is the purpose of this is for you to get a picture of the different responsibilities of the different departments in the company. And I will stick to these indices, M for management, L for legal, and so on on the next slide, which shows the toolbox. And it is a very big toolbox. Call it a strategy toolbox. And we can look at this for 10 minutes. We can also look at it for almost 10 hours. It is very extensive. So we have divided this toolbox into different compartments, and you can see it as a very basic matrix. So on the left axis, we have defensive measures that can be taken. We have also offensive measures that can be taken. And on the top axis, the right axis, we divide the different measures into relevance in a high conflict market or low conflict market. And when we talk about high conflict market, it is good to, one view is that what is the risk for us being sued or someone coming after us with IP rights. But it's also, and that is on the technology market, but also on the product market. I mean, you can have high competition on the product market. So that is included in the high conflict market. So that includes both technology market and product market, right? And then low conflict market is self-explanatory, of course. So, and for each of these measures, we have indicated with a letter which of these departments at your company that should take action. For example, in the first point here, it should be the legal department that should have the main responsibility for this measure. Any questions or comments so far when it comes to the structures of the companies? Any?
I do have a question, Casper. When it comes to the organization itself, the first slide that you presented, you said that the intern level is mainly for startups. I do understand that extern-driven innovation then is for companies that are more structured, like large companies, SMEs as well.
Yes, well, it depends. I mean, that was that we have clients, we met clients who invent a specific new product on the market. And then it's, and that was to solve an external problem that was existing. So that was actually a startup company with a carpenter actually that needed a new tool. So he started it due to need on the actual market. So, but many times when you build up the structure of the company, it's either dominated by internal research or external stimuli for it. And in the internal, it's the research department that is responsible, and in external is it typically the sales department that is collecting the information needed.
Great, thank you. It's clear.
And in reality, it's usually between these two.
Yeah.
So let's see. Let's start with the high conflict market and the defensive measures that you can take. First of all, you need a focused monitoring of the technology market. That is, you need to know what competitors, or if you're unlucky, what trolls are doing, patent trolls. And that you do by searching patent databases for new patent applications and patents, so that you have a knowledge, continuing knowledge of and updating knowledge of any potential patent rights that can prevent you your business. And that is rather straightforward, but it's not uncommon that this step is missed. And of course, then in the next step, this is research and legal in collaboration. You must do a freedom to operate analysis for each new product, and also if you plan on marketing a new product. And what that involves is that you do search in patent databases to see if there is anything that will prevent you prevent your product on the market. And if you are in a business where you must make large investments in the production, it is important to do this freedom to operate analysis early, before you invest, let's say, 40 million Swedish crowns in new equipment and then it turns out that you cannot use it. So depending on investments required for production, this becomes more important if the investments are high. And this next step, this one I think is rather interesting. We call it prophylactic publishing, and responsibility for this is typically distributed between several departments. It's research, legal, and sales. And prophylactic publishing is you develop something new, a new product, let's say, and this you decide that, well, this is not very innovative. Let's skip a patent on this one. But there is always a risk that someone else in the future will patent what you put on the market, or perhaps are patenting it while you put it on the market. So what you then do is that you publish information on your new product. And it is important that you document how, when, and where, and by whom this publication is made. And that you can present this in writing. That means that you have an actual date when you disclose this information. And from that date onwards, the corresponding cannot be patented. So you prevent others from patenting your product by making this information available. And 20 years ago, one of the big newspapers in Skåne was had a two-pager describing inventions. That was the way it was done 20 years ago. Nowadays, you can use YouTube. We have had a client that we advise to use YouTube. And YouTube, even though it's a video, you can use it by making screenshots every 10 seconds. And if there is a speaker in the video, you write down every word that he says in each frame. So that means that the video, if you need to use it in the future, will become perhaps 120 pages or so that you can present to court. But still, it works. And that works both under European praxis at the European Patent Office, but also at the US Patent Office, USPTO. So praxis is already established for videos. So this is a fun one. Has any participant here done any prophylactic publishing? Would be interesting to know. Perhaps not.
Casper, I have a question here.
Yeah.
With that you have just explained, that is not only a protection through a patent, but also through a publication. It is obvious that the mapping, the first step, that the monitoring of the technology market is crucial to avoid investing a lot in products that you may not be able to patent. Maybe for large companies, of course, you have systems. I have two questions here. Is it possible, and mainly thinking about the startups that don't have that much resources. The first one is, does exist some of patent platforms for research in which patents exist, maybe at the more intellectual property level, which are for free? And the second question is, like, how does this process look like? It sounds that you need to work even from the very beginning with law firm to be able to map this and take strategic decisions in the business level.
Yeah. There are to my knowledge, no. Now we're talking about the freedom to operate analysis, and to my knowledge, there are no good tools for an unexperienced user to use. So most times, and the freedom to operate is a document that is self-contained and where that you can use, for example, to show investors, look, we have made a freedom to operate analysis. So you can use it in-house. Typically, that is how it's done. Typical cost for freedom to operate analysis is about 5,000 euros. Okay. Yeah, so and that is a service that, of course, we provide, freedom to operate analysis. But it's important from our perspective that again, that it's a self-contained document that you can use internally and externally. Yes. In the next step, this is remember that we are still on the defensive actions that you can take or measures. And this is where management and legal more are responsible. And that is oppositions, third-party observations, protective letters, declaration actions of non-infringement, and invalidity actions. That is, an opposition is if you have a competitor and you have identified that they have been awarded a patent that will prevent you from prevent your business or be negative to your business, you can file an opposition against that patent. And you file an opposition at the authority that has awarded or granted the patent. Typically within 9 months of grant. And that is, and then you say, well, you have a patent. You tell the authority, well, you should not have granted a patent on this because of, and then you do the work that the examiner should have been done, should have done. So, and that is rather common. I've seen statistics saying 6 to 10% of all European patents are subject to opposition procedures. That is old statistics 7 years back, but still. And typical cost for opposition procedures is 25,000 euros from start to end. It's rather costly. And that is a solid, good one. Of course, it can be made cheaper. Alternatively to an opposition is to file third-party observations, or erinran, as it is called in Swedish. And that is that you, during the process, the examination process, a patent has not yet been granted, you have a patent application. You file a letter with the authorities saying that, oh, a patent should not be granted because. That means that you make the examiner aware of different problems with the patent application, making it harder to for a patent to be granted. That is also rather common. Third-party observations, much cheaper than oppositions, of course, because when you file a third-party observation, you are not party to any proceedings. You can do it anonymously. While in opposition proceedings, you are a party to the proceedings. So typical cost for a third-party observation, 2,500 to 5,000 euros, depending on the complexity of the case. The next step is protective letters. That is also a defensive measure. And that is something that has not been common in Sweden, but in Germany it's big business. A protective letter is filed with the courts. A court. If you have a competitor that has a patent and you expect them to perhaps file an infringement action against you based on that patent, you can at that court file a protective letter. And the protective letter is filed and it will be remained secret at the court. The patent proprietor will not be informed that you file a protective letter. And if the patent proprietor then files an infringement action against you, and they ask perhaps take some measure to disrupt your activities, they will first look at this protective letter before taking any actions against you. Sometimes they can take actions against you without informing you beforehand. So these protective letters are important in Germany, where they have this praxis. It will become relevant now in Sweden with this unitary patent that is in pipeline, as you may have heard, because they also have procedures for and praxis for protective letters, which will be new to Swedish companies. And then, of course, there are these classics. Next step, you can always at a court, if let's say a competitor has filed a warning letter or sent you a warning letter that you're infringing their patent rights, but they do not take any actions after that, you can go to court for and request a declaration of non-infringement from the court. That is one measure. It's not very common. And of course, also you can make an invalidity action, file an invalidity action, and that is that you say to the court, this patent is not valid because of this, this, and this. And that is more or less like an opposition, as I described, but you do it at court after the opposition period has ended. You can do that at any time when the patent is alive, or even afterwards. The next step, this one is interesting, and this comes. It may be relevant if your company has European patents. Most likely at the end of this year, the unitary patent system will come into action. And that and the unitary patent system means that we have central courts in Europe determining questions like infringement and invalidity. And there are many countries that are party to this convention. Among them is Sweden and Germany and France and Italy and Poland. And that then, and this that means that if you have a patent and it is a unitary patent, that means that a competitor can file invalidity action at one single central court in Europe that will have and the decision will then have an effect in all countries that are party to the convention. That is rather dangerous. So defensive action would instead be to, instead of having a unitary patent, have a patent in each and every individual country, because then if the competitor wants to file an invalidity action, he must do it in each and every country. Much more expensive, much more harder. Now, when the unitary patent systems comes into force, all existing European patents will automatically be under the jurisdiction of these new courts. They will not become unitary patents, but they will fall under the jurisdiction of these new courts, which means that they are subject to this procedure of a central invalidity action. So when this system comes into force at the end of this year, you should opt out these European patents. You can choose and inform the authorities, we would not wish to have unitary effect of our European patents. And that if you have patents, your patent attorneys will inform you on that one. These are the defensive measures. Okay, questions on defensive measures? Offensive measures. Now let's say that in the high conflict market, in the defensive measure, we had a focused monitoring of the technology market. Here instead, as an offensive measure, you should monitor the product market. And of course, it's the department best suitable for that is the sales department. They know the market, they know the competition on the actual product market. So they should monitor. They should go to fairs and monitor the competitors' portfolios. And the reason is, I mean, you need to identify if they are so to say infringing any of your patent rights, and so that you can take action against them. And if you see something that is suspicious, you inform your research and legal department, and they make an infringement assessment on what the sales department finds. And that is classical setup. And then there is also these classical actions, of course, and typically it's the legal department that takes action. It's sending warning letters, infringement action, and offer licenses. And one comment here is that you should not send warning letters yourself. You should always consult an IP professional before sending warning letters. And the praxis and jurisdictions regarding warning letters differs between different countries. So if you have a Swedish patent attorney, he should not send any warning letters to a UK company, for example. It is important that these matters are handled correctly. Another offensive action you can have is I mean, assuming that you have a patent portfolio and you have patent applications in pipeline and that are prosecuted by the authorities, you should try to achieve grant as fast as possible, so that you can actually use your patent rights. So accelerated prosecution at the patent office is recommended. And that is typically the legal department that takes responsibility for that, communicating perhaps with a patent attorney. Next step is also important. Next action, that is marking of products. For example, if you have a patent application or patent, you should say patent pending or patented, and then write your the corresponding application number or patent number on the product. And this marking of products, of course, raises an awareness of competitors that perhaps we should not copy this product directly. We have to look at the IP rights that are indicated before copying it. But it also will, in some jurisdiction, will award you higher damages should you file an infringement action against them. So that is important in some jurisdictions. That is, and sales and legal do that. Very important that there is a correct numbering of the IP rights on the products. There is also the possibility of making so-called virtual markings. So on your product, you have a reference to a web page where you interactively can update your IP rights that are relevant for the product. And that is accepted both under US and European praxis. The next step is something that not many are aware of, but it's also a fairly new phenomenon. We see it in China. A huge number of utility models are filed and granted. And a utility model is a patent light. In a patent, in the examination of a patent at the authorities, they look at the concept called novelty. Is it novel? They also look at the concept, is it inventive? Does it differ from sufficiently from known technologies? But when it comes to utility models, typically they only look at novelty. So it's much easier to obtain a utility model than a patent. If then an invalidity action is started at a court, the inventiveness of the utility model will be examined, but first at court, not during examination. So what has happened then in China is that the number of utility models has exploded last couple of years. And it has been speculated that it's due to some kind of reward system from the Chinese government for obtaining IP rights. I don't know. It's been speculated. Never mind. These utility models, if you are to enter for example, the Chinese market, they put like a wet carpet over the business. You need to take these utilities models into account if you enter the Chinese market. Even though they're really bad and they're really broad, you need to consider them. Utility models are cheap. So what you can do is you can spam these jurisdictions having utility models with bad utility models, and your competitors need to take them into consideration. Even though you know that they will not hold in court, inventive step is too low, but you can use it to spam. So that is an offensive action you can take. Not available in Sweden, note. Utility models.
One question, Casper. What is the main difference between a patent and a utility model? I do understand that there is a difference between the analysis of the novelty and the invention, but when it comes to the technology itself, do people use utility models for other type of technologies, or what is the main difference to use it?
Typically, utility models are limited to products. So methods cannot be protected by utility models. So you need something tangible. That is one requirement. And traditionally, you use it for something that is not that important to your business. I mean, okay, it's not worth a patent. Let's do a utility model in Germany only. And it has a national focus, not an international focus. So that is one difference. It is, and yeah. And then we need to, of course, look at unitary patents again when it comes to offensive measures. As I said before, unitary patents, you have one or a few central courts that decides questions of invalidity and infringement. So if you want to be offensive, use it as an offensive measure, you should have a unitary patent. Because if the court decides on infringement at your favor, it has effect in all countries that are party to the convention. So that unitary patents is something that you should consider. And of course, you should opt in all existing European patents to also fall under the jurisdiction of these courts. So that is the typical tactics when it comes to unitary patents. And if you have a patent portfolio, you need to make some decision on this at the end of this year. Okay, 5 minutes only. Low conflict markets. We are now looked at the high conflict markets. Low conflict markets. Legal again. You have these oppositions that I discussed before and third-party observations. In a low conflict situation, if you are to take some invalidity action, it would preferably you would like to be anonymous. So you can do so-called strawman oppositions and anonymous third-party observations, which means that your competitors will not be aware of you being the opponent. And that is one thing. It's rather common. I've filed numerous strawman oppositions. And of course, and that is legal, so that is responsible for that. And then you have a general monitoring of the technology market. In the defensive scenario, we had a focused monitoring on specific competitors and trolls. Now, as a defensive measure, you have a general monitoring of the whole technology market. I mean, you have no very well-defined competitors, and the conflicts are scarce. So instead, you have a general monitoring of the technology market, what patents are there, and anything new. And this one, the next step, I would like to have a focus on this one. It is important. We call it documentation of prior use, and it's typically sales and development that is responsible for this one. There is something called prior use. If, say, you have a manufacturing method of some kind, and you have been manufacturing using this for 10 years, and you have chosen to have it as a trade secret, in-house know-how, how to manufacture something. All of a sudden, you see a competitor patenting the specific method that you have kept as a trade secret for 10 years. And since it's a trade secret, it's not publicly known, they can be awarded or granted a patent on your actual method that you have. But if you have documented how, what, and when, and where, who, in the context of your method, production method, and if you can show this in writing and in documentation, you are allowed to continue with this. If you cannot show it, you have a problem. So right to prior use. So documentation of prior use, important. And also, it's not only of actual activity, it can also be planned activities, but are documented planned activities that you can be allowed to have and continue with. And then again, the unitary patents in a low conflict market. Typically, we would say that you should opt in as the offensive measure in the high conflict market. And the thought behind here, or the reason is different here. It's the main advantage with a patent is the passive protection that you get. And the passive protection is that your competitors, they respect your IP rights. They do not infringe them because they are aware of them. That is passive. And I would say that a unitary patent has a greater effect in this regard than national patents. Relying on this passive protection that the patent gives, it becomes stronger if it's a unitary patent than not. So, okay, 2 minutes. Low conflict market, offensive measures. One offensive measure that is fun is if you have a patent application and you choose, you say, you know you have a competitor who finds your patent application problematic. And if you have a patent application, the competitor does not know the final outcome, the final protective scope of the patent application. That is defined first at grant. So as long as you have a patent application, your competitors are very unsure of what it will result in. So it may be an advantage that have a patent application instead of a patent, because it's low conflict. You will not use it in an infringement action anyhow. So instead, you choose just to have it as a patent application. So one tactic is then the slow prosecution at the patent offices for patent applications. Not uncommon, seen it. And of course, here also marking of products and advertising patent rights is important. It's an offensive, in this context, an offensive measure to take. And also, as I've written here, low patenting frequency. It's more focus on core patents than on different, so to say, smaller. Focus on core patents, core technologies, instead of small improvements. And one reason is typically that in low conflict markets, the time to market and the lifetime of products is longer. So you should have a low patenting focus. That's it, I believe. This is me if you want to come in contact.
Thank you so much, Casper, for this very interesting seminar, and it's very good that you have put your contact there so people can get in contact with you. I would like to open the floor. We have a couple of minutes. If someone, any of our participants, would like to ask something to Casper today. Otherwise, I would like to thank you so much. I think that is with this presentation, my takeaway is that how important is for companies to actually build a patent strategy, and the documentation of prior use is like the best example of to understand how complicated that could be without a strategy, a patent strategy. So thank you so much for being with us today, Casper, and everyone. It was very nice to meeting you and having you today.
Thank you.
Bye-bye.
Bye.